Hello everyone, I am Steno Duchess and this is Steno 24/7, and right now I want to live stream to you some of my Plover practice for today. You can get Plover at any you can get Plover from GitHub. Sorry about that. I think it's github.org, and this is Plover. I believe I'm going to see if I can pronounce her name right. I'm not gonna butcher her first name, but the last name is Knight. She created this program along with other developers. It's free. It's a free open Steno project that she created, and I love her, love her for it, because it really, really helps me practice. It helps me, you know, see what I practice. I can even save my notes. So it's really, really, really a great program that you should get. And I did a video earlier about how to hook it up and how to what devices you can, what everything that you need to hook it up. I'm not going to do another video on that now, but I did do a video on that earlier, and you can find that on my channel. And I think it's called Writing with Plover is what I named it. So tonight I'm just live streaming my dictation along with my Plover, and just to show you guys again how I use this. I said I was going to make another video after I made the first video. So here is, I think, my third video now, writing with Plover. So I've got my telephone directed at, this is just the Plover stroke display, and it's on my laptop, so I just have the phone pointed at my laptop, and I'm trying to give you guys like a good view in case you have never used Plover before. Trying to give you a good view. And let me find some dictation, and I get to show you guys how this wonderful program works, which is free. So I'm going to find, I don't want to go too fast because I want you guys to see how the program works. So I'm not going to go too fast. So let me pick something at, not too slow, but not too fast. Why don't we do some, we'll do some 70 words per minute, and then you guys will see just how this works. If you've never used this before, if you have, then just join me for some practice. Okay, I did pick something, but it's playing rather low. And I don't think you're going to be able to hear it. So let me see if I can pick something that will play a little louder. 24/7. Don't mind me today. Anyway, welcome to STENO 24/7. And this is going to be selection number 13. 413 words on the subject of tax refund. Yay! Something we all like. So, let's go ahead. Put our feet flat on the floor. Sitting up straight. And write this at 100 words per minute. Let's go. This is a companion case to number 78, which was also decided today. During World War II, petitioner manufactured engine bearings. In 1944, petitioner expanded its plant in an effort to increase the output of these essential war products. At the same time, it applied to the War Production Board for certification that the various additions were necessary in the interest of national defense. However, the board granted certificates of necessity for only a part of the cost of petitioner's new facilities. In its income tax return for 1944, petitioner exercised the privilege such certification conferred by taking as deduction a sum based on the accelerated amortization of that part of the cost which had been certified by the board. In 1951, the Commissioner of Internal Revenue asserted a deficiency against petitioner on grounds unrelated to the present controversy. Petitioner subsequently filed a petition for redetermination with the tax court, claiming that it was entitled to a refund for overpayment of income taxes in 1944. The amount of this overpayment was calculated on the basis that petitioner was entitled to accelerate the amortization of the full cost of those facilities covered by the board's partial certification. Petitioner contends that the board was not authorized to certify only a part of the cost of a facility when the board had determined that the facility as a whole was necessary to the national defense. The tax court granted the petitioner's claim, but the Second Circuit Court on Appeal reversed the decision, holding that petitioner had forfeited its right to challenge the board's action by waiting too long after accepting the tax benefits of the partial certificates to attack their validity. For reasons stated in our opinion in case number 78, we hold that the board was empowered to issue certificates covering only a part of the cost of petitioner's improvements. Accordingly, we affirm the judgment of the Court of Appeals.
Night of Too Many Stars is going to have the biggest film actors, your favorite television personalities, the best comedians, all raising money for Next for Autism. Next for Autism stands out because it funds a tremendous amount of educational spaces and innovative programs that help people with autism.
Hello everyone, welcome to STENO 24/7. Don't mind me today. Anyway, welcome to STENO 24/7. And this is going to be selection number 13. 413 words on the subject of tax refund. Yay! Something we all like. So, let's go ahead. Put our feet flat on the floor. Sitting up straight. 429 words on the subject of condemnation proceedings at 100 words per minute. Ready? Let's write. If the issue in this case is the constitutionality of the statutory provision made for taking the property, it constitutionally seems clear. If, as I assume to be the case, the issue is the constitutionality, sufficiency of the statutory 10-day notice by publication of the hearing to assess the compensation for the land taken, I consider such a provision to be within the constitutional discretion of the law-making body of the state. In weighing the due process of condemnation procedure, some reasonable balance must be struck between the needs of the public to acquire the property and the opportunity for a hearing as to the compensation to be paid for the property. Just compensation is constitutionally necessary, but the length and kind of notice of the proceeding to determine such compensation is largely a matter of legislative discretion. The minimum notice required by this statute may seem to some to be inadequate or undesirably short, but it was satisfactory to the lawmakers of Kansas. It also has been upheld by the Supreme Court of Kansas and the United States Court of Appeals for the 10th Circuit to proscribe it as violative of the federal Constitution fails to allow adequate scope to local legislative discretion. Accordingly, while not passing upon the desirability of the statutory requirement before us, I am not ready to hold that the Constitution of the United States prohibits the people of Kansas from choosing that standard. Particularly, I am not ready to throw a nationwide cloud of uncertainty upon the validity of condemnation proceedings based on compliance with similar local statutes. Since 1889, it has been settled that notice by publication and condemnation proceedings to take and to fix the value to be paid for the land of a non-resident comports with due process. I agree with the court below and with the opinion of the Court of Appeals for the 10th Circuit rendered in the comparable case of Collins versus Wichita, which came to our attention at the last term of court and in which certiorari was denied. Therefore, I would affirm the judgment here. And that's certiorari. Kind of hard for me to pronounce. It's C-E-T. Excuse me, it is C-E-R.
You know, it was probably the best psychic reading I've ever had. I really felt like that she knew me. Gosh, I got everything I can imagine from my reading. She had names. She had so much detail. The reading was unexpectedly warm.
Visit CaliforniaPsychics.com today.
This is going to be case number 11, 1 1,000 words on the subject of assault at 140 words per minute. I'd like to take the time to say thank you for all my subscribers. And I would also like to say that if you have not subscribed today, will you please take the time to come over here to STENO 24/7, hit the subscribe button so that you don't miss any videos. And you can also hit the bell for notifications. It would really make me very, very happy if you would do that, because I'm still trying to get 100 subscribers and I've only got 60. And I'm thankful and grateful for the 60 that I have. But I just need 40 more to get 100. So if you can help me out there, I'll have so much dictation coming your way, you won't even be able to handle it. Now here we are, case number 11, 140 words. Let's get right on with this dictation. Question, where do you live, Mr. Jones? Answer, City Hotel. Question, and where are you employed? Answer, United Electric Company. Question, in what capacity? Answer, machine operator. Question, how long have you been so employed? Answer, well, I have been there 6 years. Question, now, were you in what is known as the Yellow Tavern on Main Street on December 24th, 1951? Answer, yes, sir. Question, and what time did you arrive at the tavern? Answer, about 9:30 that evening. Question, and did you leave the tavern? Answer, yes, I left for a while. Question, did you return a little later? Answer, yes, sir. Question, can you recall how long you stayed there? Answer, I stayed there until closing, 1 o'clock. Question, when you left there, did you go home? Answer, no. I went to the sandwich shop across the street. Question, when you were in this tavern, did you see the defendant while you were in there? Joseph Crew, the man that sits behind Mr. Keller? Answer, I did. Question, did you have a conversation with him at that time? Answer, no, sir. I did not. Question, at no time did you talk with him during the evening? Answer, not during the entire evening. Question, now, you say you went to the sandwich shop after the closing of the tavern? Answer, yes, sir. Question, when you left the tavern, where did you go? Answer, I went out on the street to try to get a cab. Question, did you tell us where this sandwich shop is located? Answer, yes, I did. It is right on across the street. It's on Deller Street. Question, which way were you walking after you left the sandwich shop? Answer, I was going north. Question, you were going north. Were you walking towards Walter Street? Answer, that's right, toward Walter Street. Question, you say your purpose was to find a cab. Answer, yes, sir. Question, did anything unusual happen after you left the eating place? Answer, I met Mr. Crew in the alley, right on the end of the alley there. Question, you were going north toward Walter. Answer, in the direction of Walter Street. Question, was anything said by either you or the defendant? Answer, he said, who do you think you are? Then the swinging started. Question, I suppose you mean that's when the fighting started. And if this is what you mean, where did he hit you? Answer, he hit me in the face, also in my eye. Question, did you have anything to defend yourself with? Answer, I did the best I could for myself. Question, if you remember when the fight stopped, tell us. Answer, no, I don't. Question, you state that the defendant is the man that was at the end of the alley. Do you? Answer, absolutely. Question, do you know if you were knocked unconscious? Answer, I was unconscious for 5 days. Question, and where did you wake up when you first regained consciousness? Answer, City Hospital. Question, and how long were you in City Hospital? Answer, 20 days. Question, 20 days. After you left City Hospital, did you return to City Hospital for treatment? Answer, I would say about 3 weeks after that. Question, you say in about 3 weeks after that. There is no question as to this man being the man that started swinging at you. Answer, that is right. Question, while you were in this tavern, did you see the defendant engaged in any other fights? Answer, the bartender stopped him from one. Stopped him from one fight that I know of. Question, you say you did see the bartender stop one fight in which he was involved. Did you? Answer, yes, sir. Question, more than one, or was it just one? Answer, that was the only one I was aware of. Question, that was the only one you noticed? Answer, yes. Question, you didn't have any argument in the bar with this defendant yourself, did you? Answer, no, sir. Question, how long after this assault took place was it before you were able to return to work? Answer, oh, about 4 weeks. Question, about 4 weeks. It was 4 weeks after you got out of the hospital. Answer, yes. Question, when was the next time you saw the defendant after this fight? Answer, it was when I was down at the detective's office. Question, you identified him as the man that called you a name on the night or the morning this fight took place. Answer, yes, sir. Question, and about what time would you say that took place on the morning of the 25th? Answer, about 1:10, 1:15. Thank you so much for watching, and I'll see you at the next video. All right, that was 140.
We let these skeptics try California psychics, and here's what they had to say.
You know, it was probably the best psychic reading I've ever had.
She had names. She had so much detail.
Speak to a psychic for $1 per minute. If it's not the best psychic reading you've ever experienced, it's free.
Thank you everyone for coming to STENO 24/7. I'm going to give you the subscription lecture. You know what to do. This is going to be case number 11, 1,000 words on the subject of assault at 160 words per minute. I have over 330 videos over here. So please subscribe. Let's get to the writing. Q&A 140, 160. Ready? That's right. Question, where do you live, Mr. Jones? Answer, City Hotel. Question, and where are you employed? Answer, United Electric Company. Question, and in what capacity? Answer, machine operator. Question, how long have you been so employed? Answer, well, I have been there 6 years. Question, now, were you in what is known as the Yellow Tavern on Main Street on December 24th, 1951? Answer, yes, sir. Question, and what time did you arrive at the tavern? Answer, about 9:30 that evening. Question, and did you leave the tavern? Answer, yes, I left for a while. Question, did you return a little later? Answer, yes, sir. Question, can you recall how long you stayed there? Answer, I stayed there until closing, 1 o'clock. Question, when you left there, did you go home? Answer, no. I went to the sandwich shop across the street. Question, when you were in this tavern, did you see the defendant while you were in there? Joseph Crew, the man that sits behind Mr. Keller. Answer, I did. Question, did you have a conversation with him at that time? Answer, no, sir, I did not. Question, at no time did you talk with him during the evening? Answer, not during the entire evening. Question, now, you say you went to the sandwich shop after the closing of the tavern? Answer, yes, sir. Question, when you left the tavern, where did you go? Answer, I went out on the street to try to get a cab. Question, did you tell us where this sandwich shop is located? Answer, yes, I did. It is right on across the street. It's on Deller Street. Question, which way were you walking after you left the sandwich shop?
test by Kumho Tire.
Nice, balanced, and controlled.
Very predictable, very precise.
It's intense. Very cool, very cool.
Kumho. Better always. Kumho Tire.
Jury charge. Members of the jury, now that you have been sworn, I will give you some preliminary instructions as to the law to guide you in your participation in this trial. I will be giving you additional instructions at the end of the trial, and I may be giving you instructions during the trial itself. By the oath that you took, you are obligated to follow the law as I give it to you, whether you agree with it or not. And you must do your duty as jurors, regardless of any personal likes or dislikes, prejudices, or sympathy. That means that you must decide the case solely on the evidence that will be presented to you. In following my instructions, you must follow all of that and not single out some and ignore others. They are equally important. You must not read into these instructions or into anything I may say as a suggestion from me as to what the ultimate verdict should be. Deciding questions of fact is your exclusive responsibility, and in doing so, you must consider all the evidence that you will hear and see in this trial, and you must disregard anything you may see or hear elsewhere. Now, the attorneys are officers of the court, and it's their duty to present evidence on behalf of their clients and to make such objections as they deem proper and to argue fully their clients' causes. However, the arguments or remarks of the attorneys do not constitute evidence. If the attorneys make, or if I should make some statement as to what the evidence is and it differs from the evidence as you remember it, you should disregard the statements and rely upon your memory. And if an attorney's argument contains any statement at any point of the law which differs from the law which I give you, you should disregard their statements and rely on mine. During the trial, I may be called upon to rule on objections to certain testimony and exhibits. You should not concern yourselves with the reasons for my rulings, since they are controlled by rules of law. Objections as to questions are not evidence, and lawyers have an obligation to represent their clients, to make objections when they believe evidence is offered, which they believe should not be offered or admitted under our rules. If the objection is sustained, ignore the question. If it is overruled, consider the answer like any other. By receiving evidence to which an objection is made, I do not intend to indicate the importance to be given such evidence. You are to disregard all evidence that I order stricken. A fact may be proved by either direct or circumstantial evidence or by both, and you should know that the law does not prefer one form of evidence over the other. A fact is proved by direct evidence when, for example, it is proved by witnesses who testify to what they saw, heard, or experienced, or by physical evidence of the fact itself. A fact is proved by circumstantial evidence when its existence can be reasonably assumed from other facts proved in the case. You will be the sole judges of when a witness is to be believed and of the weight that you should give to the testimony of that witness. Now, there are no hard or fast rules to guide you in this respect. However, as to witnesses, you should take into consideration the following: their interest or lack of interest in the outcome of the case, their relationship to the parties, their ability and opportunity to know and remember and relate the facts, their manner and demeanor, their frankness and sincerity, or the lack of it, the reasonableness or unreasonableness of their testimony in light of all the other evidence in the case, any impeachment of the witness, and finally, any other factor that you believe bears on believability and weight. So in the last analysis, you will rely upon your good judgment and common sense. Some witnesses will be allowed to express an opinion. In determining the believability and weight to be given opinion evidence, you may consider, among other things, the education, training, experience, the knowledge and ability of the witness, the reasons given for the opinion, the sources of the witness's information, and those factors that I have already mentioned for evaluating the testimony of any witness. Opinion evidence is entitled to neither more nor less consideration by you than other evidence presented. You are to judge its believability and weight in the same manner as other testimony. Now, testimony may be presented to you by way of videotape or by videotape deposition or by a simple deposition read. The testimony of a witness who, for some reason, cannot be present to testify in person may be presented in this form, and such testimony is under oath and is entitled to neither more nor less consideration by you because it is presented in that form. You are to judge its believability and weight in the same manner as you would had the witness been present in court. Now, a few words about your conduct as jurors. First, you should not discuss the case among yourselves or with anyone else during the trial. At the end of the trial, you will have as much time as you need to discuss the case among yourselves to arrive at a verdict, but that is at the end of the trial and not during the trial. Second, do not read or listen to anything touching this case in any way. If anyone should try to talk to you about it, bring it to the court's attention promptly. Third, do not try to do any research or make any investigation about the case on your own. Fourth, do not form any opinion until all the evidence is in. Keep an open mind until you receive all of the evidence. Listen to the final arguments and receive the final instructions from the court, and until you start your deliberations at the end of the case. Fifth, make a mental note of the seat that you are in and return to that seat after every recess and at the beginning of each day's activities. And finally, when you go home, friends, family will naturally be curious as to what you have been up to during the day. Tell them that the judge has instructed you that you are not to discuss the case with anyone, and that includes them. And when you get home, if something happens to be in the newspaper or on the radio or on TV, and it pertains in any way to this case, shut off the TV or radio or leave the area and tell members of your family to simply stack up the papers if there is anything in it until the trial is over. It is very important that your decision is based upon the evidence that is presented here in the courtroom and not upon any other item. If you follow these brief instructions as I have given them to you, you will be doing your duty as jurors.